I'm RG Skadberg, attorney with CCSK Law. Many people have heard the term probate, but it, like many other legal things, is kind of ambiguous. Do I have to go through probate? Can probate be avoided? And why would I want to go through probate if it was an option? First of all, probate in Indiana, probate's different in different states. So in Indiana, we lump all of our property into a single category. And probate is triggered if the decedent has more than $50,000 in his or her name after death. So there are things we'll talk about in later videos about transferring property to avoid probate, but you can have $1 million in your name the minute before you die. But if you leverage these different transactions, after you die, you may not have anything in your name, or you have a minimal amount. So Indiana, by law, says that if you have more than $50,000 in that decedent's name, they want to go through a court process to make sure that property goes to the right people, that creditors are properly taken care of, and that we let the world know that there was some assets that someone might need to make a claim against. It's a drawn-out process. By law, it's going to take, at minimum, 6 months. To pull it off in 6 months is really not possible, but the reason it's 6 months is there's a 30-day creditor window where we have to let the world know they can file a claim against the estate. And then when the estate's buttoned up and finished, we have a 30-day period of time in which everybody could come back and question what we've done. Well, not everybody, but a specific group of people can come back and question what we've done. In the middle, the reason why it rarely could get done in 6 months is there's a month or so, just if everything's hitting on all cylinders, there's a month that it takes just to get probate opened. You have to get in touch with heirs of the estate. People have to consent. You have to determine who the personal representative might be. Was there a will? Was there not a will? That will dictate some things as well. We have to get signatures. We have to get a filing into the court. The court has to sign off on opening the probate. So that could take a month or even 2 months, depending on what it takes, or longer in some cases. That will dictate, even getting started. Once we get the probate process started, we have to put a publication in the newspaper. That's required. That's what opens the creditor window, or the creditor claim period. So we have to tell the world, hey, there's this estate open, and if you want to make a claim, here's the process to do it. We have to wait 90 days. At the end of that 90-day period, we can close the creditor window. There's some other nuances in there that we won't get into in this because it may or may not apply. But once we get that done, we have to also be gathering property. We have to inventory things. We have to appraise things, get values, current day values, in order to put together the inventory that we give to the heirs, and in some cases the court. Also goes in the public record for people to see. And so that's the process that we're going through during this 90-day period of time. Maybe we have to sell property. Maybe we have to protect property. There's lots of little things that have to go on during this period. But one of the big things that people don't understand is we're not distributing things yet. This is just about gathering, collecting, figuring out what the estate, the probate estate, might owe, and who are the heirs, and making sure that we have everything gathered, inventoried, and determined. We have to pay creditors. There's an order of who gets paid first, second, third, fourth, fifth, sixth, and we have to follow that. So, and unfortunately, what a lot of people don't understand is heirs are the last ones on the list. So that's why we can't distribute property until we make sure that everything else has been taken care of, because we don't want to pay somebody down the line if somebody up the line is owed money. My hope is that we can avoid probate. It is completely avoidable. It is not required in the state of Indiana that you go through probate. You can do other things to put together your life plan, as we call it. When we sit down and we talk about, we have things, we want to take care of people, we can do all that outside of probate. It's a much more efficient process in most cases. It's certainly out of the public record when we do things with transfers and trusts and things of that nature. So we can put a plan in place to know what's going to happen with the things in our lives, to take care of the people in our lives, and do it completely outside the probate court. It takes planning, though. And the other thing, a will does not avoid probate. A will is basically your instructions to the probate court. you know, here's who I want to be the personal representative. Here's who my ultimate heirs are. That's basically you saying to the court, here's what my wishes are. It doesn't avoid court. The other planning and things that we might do to reduce those assets in a person's name after passing is what we have to do to avoid probate. And from my perspective, there are only 2 instances I can think of where I wanted to go through probate because it was a very contentious situation and I wanted the court to take lead and protect all the heirs from maybe one heir trying to come in and take over or bully other folks or whatever it might be. But in most circumstances, I want to avoid probate. I want to do things efficiently and also less expensively. Probate is time consuming. It's all in the public record now, and all that public record is online. People don't understand that. Your heirs are going to be named on a document with their addresses. There's going to be this inventory that people can access to see what was in your estate. You're inviting people to make claims. And there's a lot of attorneys that charge a lot of money. I know we have a video out there that breaks down the example of how is probate pricing set. So it's very important to understand if you have to go through probate that there are different ways to go through that process from the perspective of pricing. So if you didn't plan ahead and you end up in probate, make sure you understand what that process is and what it costs. But as I say, probate is a costly, time-consuming, and public process that we can completely avoid if we get out in front of it and do planning. How does that work for you? Certainly we can talk about your circumstances and what would be probatable, what wouldn't be, how do we want to get assets to different members of your family or loved ones, and that's, again, very unique. I say that all the time. People's situations are far more unique than what they realize, and it's really important for you to understand your own circumstances so that you can make your own plan, and we can talk about that. We have a consultation that we do for no charge to plan to avoid probate, and I do the consultation for free to initially help people understand whether we have to go through probate as well. I'd rather have people comfortable to come in and talk about their circumstances so that we can make a good plan going forward, whether it's outside of probate or through the probate process. Thanks for visiting. I hope you found this information helpful. If you'd like to talk about your circumstances, please visit our website, ccsklaw.com, or give us a call, 219-230-3600.